Any mention?
Not item 28. Item 28. Due to some personal difficulty, my lord, we are not ready. So if matter can be taken up after 2 weeks. Madam Shala is
I'm for the state lordship. No objection, lordship. Actually, the elections are being conducted today, lordship, for the High Court Bar Association. Much obliged, lordship. When?
2 weeks, my lord.
Much obliged, lordship.
Lord. Item 30 also joint request, my lord.
Your lordship, I'm for the responding, lordship.
After 2 weeks, my lord. Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 29, Your Lordship.
After the respondent state, my lord. No objection, my lord.
Much obliged. After 2 weeks, Your Lordship. Much obliged, Your Lordship. May I please, Your Lordship? Your Lordship, I beg to mention item number 24, Your Lordship. Your Lordship, let this matter may come up on 20 March, Your Lordship, as the connected matter has been listed on the date. So it's WPC 363/2021, Your Lordship. Yes.
Not really tagged together, my lord, but they may travel together because they arise from the same order. Yes, my lord. They may travel together.
Let it be on 20 here, Lordship.
20.
Yes, Your Lordship. 20. Highly obliged, Your Lordship.
Okay, very good. On 20th. Obliged.
Please, Your Lordship, I beg to mention item number 21, Your Lordship. I humbly pray for 3 weeks' time, Your Lordship. Yes, Your Lordship. Respondent 3 to 4. Yes.
Let it go. No, listen.
Three weeks, Your Lordship. Yes. Highly obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item number 31. I'm praying for 2 weeks' time, Your Lordship. Yes, Your Lordship. We want to do some personal difficulties.
No objection.
After 2 weeks, Your Lordship. Much obliged, Your Lordship. May it please, Your Lordship, I beg to make a mention of item number 20, Lordship. 2 more, Lordship. 20, Lordship, 20. Lordship. Petitioner, Lordship. One I am for the private respondent for 22, and 26 I am for the petitioner, Lordship.
Lordship, for 20, no objections, Lordship. For 22, Lordship, this state Lordship.
Body petition.
26, Lordship. Lordship.
Mr. Hazarika is for the government.
Lordship. No objections, Lordship.
After 3 weeks, Lordship. Value.
My lord, because of bar elections today, my lord, I am contesting, my lord. My lord. My lord. 23, 25 and 27. 23 and 25, Mr. Sivasi Sen is on the other side, my lord. I am for the respondent. He is also contesting. Oh, no, Sivasi is withdrawn.
He's withdrawn.
He's withdrawn.
Withdrawn his currency. No objections, Lordship. Lordship, I'm here for 23 and 25, and sir, you were saying?
And 27, Mr. Pandit is on the other side, my lord. This is a CBI matter.
Lordship.
2 weeks. 2 weeks.
Obliged.
Supplementary cause list, item number 1.
My lord, there appears to be a formal defect in the petition, my lord. I'll have to withdraw it, my lord. I seek to withdraw this petition with liberty to file afresh. My lord, yes, my lord, this is not exactly not quashing, my lord. This is a petition filed against the judgment of conviction, my lord. The conviction was based on a admission of plea of guilt, my lord. Now, the plea of guilt was subsequently recorded after the charges were framed, the evidence proceeded, and at a subsequent stage, there is not necessary, my lord. There are other defects as well, my lord. With liberty to file afresh. KC.
All right.
Obliged.
Item number 2.
Please, Lordship. Lordship, this is for quashing of criminal case pending in the Session Judge of Cleariot. This Session Judge of Cleariot. My Lord, this pertains to quashing of a criminal case, Session Case number 21 of 2023, pending in the Court of Session Judge Joy. Session Judge Cleariot, my Lord. My Lord, this pertains to that assault of one lady by the name of Agnes Karshe. Yes, yes. But the process has to. Yes. Obliged,
Lord.
Daily causeless, item number 1.
May I please, Your Lordship? Conducting counsel, Senior Advocate Mr. Khan on his legs, my Lord, on courtroom number 3, my Lord. Kindly, this matter, end of the board, my Lord. Okay. Obliged, my Lord.
Item number 2. Item number 3.
May it please, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file my objection, Your Lordship. Your Lordship, this is the first time, Your Lordship. In the last occasion, we've just entered appearance, Your Lordship. Once, this is the second time. Lordship, this is the second time, Your Lordship. Lordship, 2 weeks may be granted, Your Lordship. Lordship, this day.
Objection, Your Lordship.
2 weeks, Your Lordship. Hello, Your Lordship.
Item number 4.
May it please, Your Lordship. Lordship, item 4 and 5, Your Lordship, are analogous. If this both matter can be taken up on 25th, Your Lordship. Lordship.
Lord, instead of 25th, could it be on 21st? 21st?
21st is Friday, Your Lordship. So 20. Let it be 25th, Your Lordship. Tuesday.
21st? 25th, I have some difficulty. That's why.
21st.
Actually, today I came prepared and we came out the written argument also. Anyway, Milord.
25th or 26th?
21st to come. Why?
Not 21st.
26th to come. Okay.
25th, Your Lordship.
5th for final disposal, Milord.
Lordship, yes. Both the matters.
Actually,
Lordship,
for at least for admission hearing, my attempt will be made to dispose of the petition, Milord. If your Lordship would kindly.
Lordship,
yes. No, further, until further orders. Until further orders. 25th, Milord.
25th.
5th.
Apply, Your Lord. Both the cases, Your Lordship.
Item number 6.
What is your instruction?
Please, Lordship. Doctor, these are matters relating to land compensation for acquisition of land for Indo-Bangla border fencing, my lord. Now, my lord, land was acquired quite some time back. Now they've come by way of this present petition seeking compensation for the land, my lord. Now, during the pendency of the proceedings, what happened, my lord, the state government has sent a requisition of 112 crore rupees to central government on account of land compensation, my lord. Then central government, there were several meetings online meeting between central government officials and state government officials. Now it transpired the central government is asking for details on what basis they have calculated 112 crore rupees. I'll just place the latest letter. Excuse me. This is a very recent letter of 28th February, my lord. This is written by Ministry of Home Affairs to Secretary Revenue Department, Government of Meghalaya, my lord. But here, I'll just refer to Your Lordship to para 4 and 5, my lord, of this letter. In this context, it is informed that the Section 19 of the So-and-so Act deals mainly with publication of declaration of summary of rehabilitation and resettlement under the Act. The determination of awards were mandatory under this Act before considering the release of compensation amount by the Ministry to the concerned executive agencies engaged for the works jointly. Joint Secretary BM1 informed that MHA releases land acquisition amount based on the land acquisition award of the concerned district collector, deputy commissioner. Further, it is stated that the requisite clarification with regard to meeting held under the chairmanship of Secretary BME's Border Management under MHA on 16/8/24 was received from the Government of Meghalaya by letter dated 20/11/24 without endorsing a copy of the final draft award of pending demand of Meghalaya government amounting to rupees 118 crore for stretches between so-and-so and all West Garoils, my lord, and South Garoils. In the absence of the draft, land acquisition award is not in a position to examine the process, the cases. It is therefore requested that the state government of Meghalaya should verify the land records, ownership of the landowners, and provide a copy of the final draft award so that the demand of state government for land acquisition under the relevant land laws can be processed by the ministry. Malud, now state is, well, here what happened, Malud, in early 90s, Malud, Indo-Bangla border fencing was carried out by the MHA, Malud, and that time was only border pillars. Now, because of the law and order issues and subsequently, the government decided to do the border fencing by barbed wire. So this is called second phase, when the barbed wire fencing was erected on the border. For that purpose, our case is, the land compensation originally was already deposited to the government in early 90s. Second phase is only with regard to on the acquired land. Now, how, on what, my lord, on what basis they have said that you pay 118 crore rupees, my lord? Now, the state government has to justify, my lord, on what basis the requisition under 118 crore rupees from the central government.
May it please your lordship, let this letter be shared with me, your lordship. Yes. I'll have instruction in the month.
Your lordship, in this order that he has to file an affidavit regarding whatever he has make a submission. That there is an earlier order also.
Lordship, because whatever the central government has asked from the state, that has been provided, your lordship. Now with this new letter, let me have instruction, your lordship.
Well, I'll give copy.
Your lordship, I'm appearing for respondent number 9 to 13 in all the matters. NBCC.
Lordship, item number 6 to 19. Then
6, 15.
21 and 24, these are analogous.
24 also?
No, 24 also, no? Huh?
6 to 19.
6 to 19.
Sorry. Yes.
28 February.
No, 24.
Below the signature date.
Yeah.
I found from that one.
Lordship, yes.
I'm supplied.
Lordship, since this is because by this letter, Your Lordship, government of India has sought justification, so Lordship, sufficient time may kindly be allowed, Your Lordship. At least 4 weeks' time, Your Lordship. 3 weeks, Lordship, yes. After 3 weeks, Your Lordship. 6 to 19, Your Lordship.
6 to 6 to 19. Same.
The same order will follow, Your Lordship.
Second call. Item number 1.
My lord, this revision petition has been filed against the order by which the injunction petition, that is the order of injunction, has been set aside. And against the injunction order, any order passed relating to injunction, whether passed by the learned district judge, West Garo Hills, it is in respect of a title suit. Suit was instituted by the petitioner, plaintiff, in respect of a plot of land.
Whether all the suits are instituted in the district?
No. This suit is originated. Original suit is filed before the assistant to the deputy commissioner. Then this learned trial court had passed an order of injunction against that. Yes, rule 1 and 2. Against that,
Order of injunction is passed by the court of
assistant to the deputy commissioner, and against that the appeal was preferred by the defendant. And in that appeal, the learned district judge has categorically held and has decided that in respect of the patta number and dag number, what they have sought for the injunction, that very dag number does not exist.
Anyway, that was an interim finding.
No, that is the first learned trial court has waived this.
Kindly, please verify.
Kindly.
Matter had not proceeded for any final hearing. It was at it is in the stage of injunction, isn't it?
My lord.
First injunction was granted in favor of the plaintiff.
Yes.
Now it was challenged in appeal.
Yes.
Before the ADC.
ADC.
Isn't it?
Yes.
The ADC interfered with this one.
Yes.
He reversed.
He reverts the order.
Yes. By giving a finding that certain tag number does not exist.
And in respect of these other 3 ingredients of this granting injunction is also not in favor of the plaintiff petitioner. So accordingly, that order of the learned assistant to the district judge has been set aside, assistant to the deputy commissioner has been set aside. And now against that the order is appeal lies. Where is the scope for the revision? It is 108B. This is the provision is there. That is the appeal 108B. Section 108, procedure in appeals from appellate decrees and orders. And B is from orders made under this code. When there is a specific provision for appeal, how the revision is being filed?
Does it not speak about procedures, what is to be followed?
Procedure is to be.
Please read it.
Yes, yes.
Do not adopt any
Procedure in appeals from appellate decrees and orders. The provision of this part relating to appeals from original decrees shall, so far as may be, applies to appeals. B, appeal from appellate decrees. Then A, this is A is appeal from appellate decrees, and B from orders made under this code.
That's all. But it speaks about the procedure.
Yes. Then
does it empower? Is it an empowering power? Does it create a provision of appeal? Does it say an appeal can be up to section 96, see section 100, see the language used there, and see the language used there?
My lord, that regarding this, that the against this order, there is the injunction order. If they are aggrieved, then the appeal provision is there, as it appears.
See, appeal under order 42, rule 3 probably, rule 1R.
Rule 1R.
That is all right. That is so far as the appeal which was prepared before the original deputy commission.
Yes.
But then now they are against the original deputy commission, not of the they are against. They are not. They have not come against the order of the time.
Now, my lord.
Now they show us that appellate order passed in injunction matter can be appealed. Where is the proof?
There is the appeal against the order. There is a second appeal against the order. Then
you make your argument. You see, it is not that thing. Are you saying that section 100 will apply in injunction matter?
My lord, this any order, because in this regard, the Supreme Court authority that I relied on, there it has been categorically stated that there is no scope for the Honorable High Court to exercise this in an injunction matter under 227.
You see, injunction matter, what? Injunction, see, first appeal and second appeal. Injunction, if there is a direct appeal from original order trial court, appeal lies, definitely.
My lord.
But then, so far as the order of the appellate court is concerned, where is the provision?
This very.
Section 100.
My lord, section 100 is the regular second appeal against regular second appeal. It relates to the second, relates to decree.
The first submission was section 100.
Yes. One.
108 doesn't create, doesn't enable a party to file this. It only says the procedure what it is.
Then there itself provides that
procedure and appeal from appellate decrees and all.
Yes.
The provisions of this part relating to appeal from original decrees shall cover as may be applied to appeals.
Yes.
From appeal from decrees and from orders made under this code. Which order?
This order that has been passed by the learned district judge.
So any decision to verify yourself that an injunction matter that can be further appeal from the order here. This court is not satisfied with the plea. What your decision is?
The decision that I relied on, it categorically stated that kindly.
It is reported in what?
Is Supreme Court. It is reported.
What is the citation?
Citations is Virud Nagar Hindu Nagar. Citations is of this thing. It is AIR online 2019 Supreme Court 2619.
Any equivalent citation of SCC?
Yes, any equivalent citations of SCC 2019 volume 9 SCC. I am having extra copy.
What is the fact in this case?
Fact in this case is also the same thing, that the injunction order has been passed, and against that injunction order, this thing appeal, instead of this appeal, the revision has been preferred. Yes, my lord.
This revision is not directly agreeing to order of the trial. Is it a similar situation here? It is better.
If lordship,
Law which you are citing is they are very classic. You don't know, you are what is the problem in telling us the factual things?
my lord,
Yes.
so far as this matter is concerned, here the two things are there. One is that the appeal was preferred, the revision was preferred against the granting of injunction. The revision was preferred, and rejection of the injunction order, revision was preferred. This no, that is not the first order.
No, Lordship has got the fact very clearly. I'll just reiterate what Lordship is. Lordship, the factual situation is, I got an injunction order in trial court in my favor after contesting, and then they file an appeal under Order 43 Rule 1R. So they did not choose. No, we had no option. No? Yes, that fact is not clarifying it. I have come on. And what Lordship, that's why Lordship is getting the facts very clearly, but he's not bringing that fact, and he's not relying on that judgment. On fact, this judgment will not be applicable.
My lord, so far as this judgment I have relied on of the Honorable Apex Court, that directly involves the provisions of law, and so far as the provisions of law is concerned, as it is this thing, this is para number 14, may kindly be perused. That therefore, wherever the proceedings under the Code of Civil Procedure and the forum is in the civil court, the availability of a remedy under CPC will deter the High Court, not merely as a measure of self-imposed restrictions, but as a matter of discipline. And 2036 SCC 7567. My lord, here they can come on appeal before the Honorable High Court. That provision of law, if the injunction is rejected, in that case, as per me, it is under section 108. That provision is specifically mentioned. Section 108, as I have read out. Yes. If it is allowed, then also it can come. There is a provision for second appeal against the order.
Lordship, I don't think so. Lordship. No.
As far as the 108 is concerned, we have to have some decision on 108.
Yeah, especially yes. If he comes with 108 specific decision on 108, Lordship, then we can be very clear on the position of law. But what Lordship has said, then whether the moment we say 108, whether 100 will be applicable, second appeal. That is the. And it's absolutely Lordship. Absolutely Lordship, yes. On 108, yes. If we can get a specific decision on 108, yes.
Then, my lord, this.
Probably there was a scope for him to raise that why it is under why not formal. That is definitely something. Because even if it is revision, then provision of revision is provided in
115.
where actually doesn't like 115. They should have invoked 115. That argument probably doesn't. Subject to what he says. This court is not an expert. You must be doing that. So you have to verify on the one. Some decision which says that if this in the present or the similar factors of appeal is
The revision is not maintained.
because normally this court has not come across any second appeal during its tenure as second appeal. So if you say 108, 108 is not.
Okay.
So if you go over the language, see 196, 100, or see provision of section 100, come to 108. You can't there be huge difference.
Now, my lord, in that case, there is another scope. The another development is that the petitioner side, they have, I don't know why they have not disclosed, they have filed an amendment petition before the learned trial court in respect of the schedule of the properties. Yes, and I am having that this copy. Now, so far as this case is concerned, they have filed this petition for amendment.
Are you giving up the issue of 108?
No, no.
Satisfied that.
So far as I have exactly, my lord. So on this,
only on that, yes.
On
absolutely. Other party lordship will reply.
Then, my lord, as my lord needs the clarifications on that, what should be the provision, that whether the section 108 is applicable or any appropriate provisions is there against the appellate order, whether they can come up under article 227 or not. Regarding that, I may be given some time, I will highlight.
You have raised the question of law.
Yes.
This court also would like to be enlightened.
That for that only.
So you will do the research and you will make the court.
I will try to place this thing.
Lordship, just one judgment. No, I will not bother. Lordship, only para 22. Just. Lordship is aware this law has been settled way back in 1998, but 2015 is retained. Para 22. For a moment, Lordship. And your lordship, the latest. Absolutely, lordship. The forum. I'm not lordship. We still go back to the primary argument. I am saying even if you come up with a Supreme Court judgment on 108. Absolutely, absolutely. Yes. Yes. If he comes up with 107, Lordship, my defense would be that this whether the substance is whether Honorable High Court has got power or not. If he can satisfy with the judgment of 108, then the onus will be on me to satisfy. Let him bring. And
The
Lordship.
latest, my lord, the latest that judgment I have placed, it is of 2019, where the Honorable Apex Court has categorically held. So I will, I will enlighten. I'll try. Constitution. That absolutely, yes, absolutely, my lord.
Now, apart from that, 227 is forwarded to the state. It is not just that it can be invoked at the mayor asking for it.
Definitely.
Absolutely.
Right now. Those things definitely unresolved.
Yes.
But then you have asked initiate by that.
The revision is not maintainable. On that, I will place. I will try to enlighten the
But Lordship, let me reply very important issues. I don't think so. He's in the position to make the submission for the simple reason. His application, the injunction was given by the Assistant to Deputy Commissioner under the rules 36A. And Lordship is aware 36A, Lordship has dealt at length during his career as a lawyer. 36A gives a couple of power either for appeal or revision. Either or. And our Honorable High Court has held very clearly, if you exhaust the remedy of appeal, if you exhaust, they have exhausted the remedy of appeal. They have exhausted the remedy of appeal. So this will not be technically guided only by Order 43 Rule 1A, because it will also be guided by 43 Rule 1A. Now his petition itself is not maintainable because he is appealed against before the district judge. His petition in Lordship is before the district judge. Lordship, both coexist. Both coexist. Now that this Honorable High Court has never had an occasion to decide on that issue whether what will be happening. Yes. Absolutely. Now, Lordship. But if 36 rules of administration of justice has not been recalled or overruled, then the appeal will lie under 36A. But there is a provision under the Administrative Justice Act which says spirit of CPC will be applicable. Now that has to be read. Letter of CPC has to be applicable. Yes, yes. Parametric with 115. Lordship, yes. Lordship, I am into this issue. Absolutely. Or no, High Court. Absolutely. Yeah, my Lordship, my only limited question is this. Lordship will kindly appreciate. Against Assistant to Deputy Commissioner, no appeal will lie before the district judge. Court can remand back the matter. EDC, but he is filed before district judge and under Order 43. Totally, the petition itself is not non-est. But then the only issue is, Lordship, Assistant Deputy Commissioner, whether appeal will lie under Bengal Agra Act to district judge or under the Administration of Justice to Additional Deputy Commissioner. Now, if he has preferred an appeal, court will strike down the entire proceeding as non-est and remand the matter back. No, Lordship, but the issue of jurisdiction has been brought here. Now, will the court, we have not challenged that part, Lordship, yes? That is where, Lordship, that is where we have come under, Lordship will kindly appreciate, that is where we have come under. Lordship is correct. The same thing will apply to me even if he brings out 108. It is not the issue of quorum non juris that this High Court doesn't have to do. I am into, Lordship, I am into very limited thing. Lordship, I am into very simple issue, Lordship, against Assistant to Deputy Commissioner, where will the forum lie if Administration of Justice of Appeal has not been recalled and CPC has been made applicable? 20?
2022. 22.
2024, earlier sometime in 23. Later, Lordship, yes.
The exact date I not in permission.
But suit was filed prior to that. Absolutely.
Because, my lord, as it appears that the suit was this thing verification affidavit shows it is on 16 September 2022. The verification affidavit. We will enlighten the learned court. Okay. Yes, I will bring the 108 as well as the other appropriate provisions that CRP the 227 does not apply before the Honorable High Court so far as the injunction matter is concerned. To that I will bring.
And Lordship, I just craved the leave of the Honorable Court. My friend has made a mention that after the filing of this, we have filed an amendment. Lordship, that occasion never arose because the issue of maintainability was that. We were bringing into our information on that. It is a statement of fact, Lordship. We just craved the leave of the court. Absolutely, Lordship. Lordship, and we'll try to bring on to. Yeah.
My lord, the very the revision petition that they have filed, there it contains. And I will enlighten the learned Honorable Court. Their very revision petition itself shows. Dina. Yes. Last order. My lord, let it be in the first week of April.
There's Lordship, a small submission. Lordship, there was an interim order passed on 13 which is continuing. So.
My lord, so far as this interim order is concerned, it is our very source of earning livelihood. It is. I see. Deeply less.